Hello and welcome to another session of In Session with Judge Ashley Wilcott and Michael Ayala. Just to remind you, there we are. There it is. There we
There
are.
it is.
All
It's
right.
official. Look at
It's
us
official. I love that
in
poster, by the way.
session.
But Ashley, great to see you. Thank you so much for being on with me today. We got a couple of things we want to talk about. We're going to begin with a quick debrief and get on the record regarding the Carmelo Anthony case. You and I haven't had a chance to really break that down at all, so I wanted to do that. We're also going to talk a little bit about the Kyle Bevan case. Folks may not have
No,
heard of
that's
this. This
fine.
happened over in Wales, but it's going to jump off another discussion about inmate justice. You guys are not going to want to miss that story. And then we're also going to be talking about an interesting case involving a cross-dressing man and a very popular outdoor um,
Clothing brand.
apparel right, an equipment company, Patagonia. And I won't give any more away because I want you guys to stick around for that story. It's really an incredible story. But Judge Ashley, as I said, I want to begin with the Carmelo Anthony story. We haven't gotten on the record
Mhm.
together. First and foremost, I just want to get your thoughts. I've cut together a short video of some of the important parts of all that evidence dump from Collin County. But first, just want to get your thoughts on the case. I've expressed myself many times on various platforms, but I'd love to get your thoughts about that case.
Of course. Always great to be on together again, Michael. And listen,
Absolutely.
I haven't talked on any of the media outlets that I participate in about this particular case. So this is really first blush for me to actually talk about it. A sensitive case, a lot of eyes on this case, a lot of very strong opinions on both sides on this case. My immediate takeaway, and I told you this the other day when we talked briefly, my immediate takeaway is why in the world did Carmelo Anthony not testify? Self-defense, one of the defenses, affirmative defense. I fully expected him to testify. Of course, it's his choice. It's the client's choice to testify or not. But what it made me think after the conviction was, what do we not know? What more is there? Because I promise there's more that we don't know. We don't know what's in any of the motions that haven't been released. We don't know what all the arguments have been. We know no media was allowed. And I just think, Michael, there's so much more to this case that we don't know.
Judge, I'm so glad you said that because that's kind of what I've been expressing. And because this case has been so polarizing, I got
Yeah.
a lot of really angry pushback on that, as if I'm saying he's not guilty of something or whatever. No,
You don't know.
I, I try to tell people my 30 years of experience in and covering trials tells me there's stuff here that seems off that we don't know. And so now when we see these new attorneys coming in to handle the appeal, it's not about getting Carmelo off. It's about maybe getting some answers to the things we don't know. And I agree with you. Him not taking the stand, big issue in this case, might have changed the outcome. I don't know. The other thing that I think was a big decision in this case was the judge not allowing cameras inside, not just because you and I make a living talking about trials, and that's definitely part of it. But this was such a polarizing case, and it was clear going in it was a polarizing case. As a matter of fact, that was the reason the judge gave for not letting cameras
I
in
was just going
when
to
it
say
should
that.
be the reason for letting them in.
That's what I think too, and that is what the judge said. They didn't want
Hmm.
to make it even more polarized, but the problem with that, and I'm not bashing this judge, I'm saying as a system, the lack of transparency is a problem because
Right.
when you don't have all of the information, people are going to start to make assumptions and to speculate, and that's a dangerous place to go. And and I want to echo what you said, Michael. Somebody asked me, "Do you think it was self-defense or do you think that it was murder like the jury found?" I said, "I don't know. I don't know enough evidence. I would want to know specifically what was said inside that tent. I would want to know we have different witnesses saying different things. People are accusing, and there are different statements than those made on the stand for some of the friends. Unless you have more of that information to give the context, it's hard to know. But there's one particular fact I have to mention, and that is for it to be intentional on the part of the defendant, and we know that's what the jury found, intentional act. If I would believe that if an individual was planning to intentionally murder someone, they would have something more than a 3.5-inch knife as the weapon of choice. One of the murder definitions in the state is intending to cause serious bodily injury and committing an act clearly dangerous to human life. Maybe that's what the jury found, not the
Yeah.
intentional, but intending to cause that injury. I just think the intentional's not there because of the size of the weapon. That's just my opinion.
Yeah, and I think I agree with 100%. I understand why this jury may have decided the way they did. They had the one-sided narrative in this case
Mhm.
that came directly from prosecutors. You have the conditional threat by Carmelo Anthony. When he puts his hand in his bag, they're saying, "Ah, you got nothing in the bag." At least this was what the testimony said. And then he says, "Touch me and find out." That gives this jury the opportunity to say that this young man was aware that whatever was in his bag could cause serious bodily harm. When he is pushed and he causes that serious bodily harm, it's hard to then argue that he wasn't aware that he could cause serious bodily harm. And you're right. Under the murder statute, you don't have
Yeah.
to just intend to kill. You have to also, you can intend to cause serious bodily harm that results in death. So there's that. And again, my argument has always been the push then creates a situation where he's responding to the push and he's reckless in his actions. I don't think he really was contemplating killing anyone. To your point, you don't carry a 3-inch knife to kill someone. It goes into the heart only 2 inches. If you're intending to kill, you're plunging it in. Why
Yeah.
not all 3 inches? I also feel like getting someone and stabbing someone under the circumstances, I'm going to play the tape in 1 minute, where there's this pushing and shoving going on, and landing directly in the area where it goes into the heart 2 inches is very difficult because, to be honest with you, if I asked most 17-year-olds, they couldn't tell you exactly where the heart is anyway. It's not right in the center of the chest. It's off to the left side of the body, just under a couple of ribs. So it's got to be perfectly placed. So I think it went there as truly unfortunate. I think he
Mm.
meant to hurt the guy. I'm not sure he meant to kill him. So I think either one kind of fits. And it could have changed if this jury had more of an understanding of what was on his mind.
And I will say this, you and I have talked about this. Knives are nasty.
Yeah.
It is astounding to me how many trials we've covered or crimes we've talked about where a knife is the weapon of choice. And it can do deadly, fatal damage so quickly without the person necessarily realizing that's the threat of a knife. And so I think you and I talked about this. If this were the good old days, so to speak, a long time ago, this would have been a fist fight, right?
Yeah.
Maybe a fist fight would have resulted
Black
because,
guy, broken nose,
yeah,
everybody
I
goes
have no
home and
doubt there were words, there were shoves. I think that happened. And so, honestly, for me, the travesty in all of this is I think the unrealized fatal consequences of a knife wound.
yeah. And I struggle with the idea that these 17-year-old boys contemplated that someone would die. I just have a problem with the totality of the circumstances. I want to play the video quickly right now. It's about 1 minute and 15 seconds. I
Uh-huh.
cut together. I'll try to kind of walk you through it as I'm playing it here. So this is the group of 6 boys walking in. That includes Hunter and Austin. They're walking into the stadium. This is from one of the far cameras. I only did a little bit. They continue to walk, so now they've split up. There's 3 up front, if you can see them, and there's 3 behind them. The first 3 go up the stairs, 2 keep going, and that's Hunter, I believe, and then Austin is here, and those 3 boys walk up, and they walk over directly to Carmelo. It's about 6 minutes past. I just went forward in the tape. 6 minutes or so, they're going back and forth. Watch closely. When the one kid here leaves the tent, right
Mhm.
after it, you're going to see pushing and shoving.
Yep, right in the
Boom,
back
right
under the
there it
yellow.
happens. Yep.
Yep.
And he leaves the tent. Then he goes running. It's interesting. He runs a little bit, falls down, then he keeps running. I cut again. Then you see him stop running and stop
Mhm.
and want to go back, but he sees another kid chasing him. You'll watch the kids come and starts chasing him. He runs again. After that, he runs around the track. He goes onto the track. That's him on the track. And that's when he goes and talks to the coach. Coach says he's very emotional. He's telling the coach, hey, coach, I told him not to touch me and blah, 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 blah. And he's very emotional at that point. Shortly thereafter, the police come. They handcuff him, take him, and he makes those other statements. That's just generally it. You can't tell very much. The closer you get, the more grainy it becomes. It's hard to believe under today's circumstances with all the technology. Can't get a clearer picture, but you can, right? You see some pushing and shoving. I can, on one hand, understand that a young man sitting there by himself feels fear. Four guys all outweighing him by 60 to 80 pounds, standing over him. He feels threatened. He remembers he's got a knife in his bag. He decides to make sure they don't touch him, so he threatens them with that particular thing. On
Right,
the
and
other
does he
hand,
threaten to
go
kill
ahead.
him? I don't know. I'm not
Right.
convinced.
They
Did
didn't
we
say
have
that.
evidence
No one
to suggest
testified that he threatened to kill them.
exactly,
But the
exactly.
implication is, I got this in my pocket. I'm going to hurt you if you mess with
Sure,
me.
sure, of course, I
They
agree with that.
decide to mess with him, continue, and he takes
And it
action.
was yeah, and it was reckless. I have no doubt it
Mhm.
was reckless. So maybe it's that definition of murder the jury convicted him on, or it could be a manslaughter case. I mean, again, I firmly believe in this particular case, hindsight being what it is, the only way the jury could have considered self-defense is if he testified,
Yeah.
and he chose not to.
Yeah.
And that's just my opinion about
Yeah.
it.
Quickly, I want to talk about the new attorneys that have joined the case on the appeal. Initially,
Hard
it was
hitters.
going to be public defenders, appeals division. I've known many people who've worked there. Those are excellent attorneys. But now we've
Mhm.
got some specialists coming in, folks who specialize in civil rights law, appellate law in the Dallas area. It is their home court. As a matter of fact, a couple of them have practiced in front of the appellate court that's going to be considering this. All those things are a positive. There are some issues out there that may have to be addressed. Just quickly, your thoughts about them. And I want to put this up because they're also playing um, the public relations game. And let's see, I don't think I have
Oh,
it.
yeah,
Where's
the
Oh,
court
yeah,
of
here it
public
is.
opinion, and
Yeah,
while
the
you're
court of
pulling it up yes,
yeah. So
right?
they've started a website called I Stand with Carmelo, putting information up there to keep people informed, something that at the original defense did nothing of. There was a gag order on the case, so all that's understood, but now they're doing this. So quickly, your thoughts on their joining the case at this point.
Oh, boy, the attorneys who are joining are hard hitters. They know how to appeal. They know how to engage the court of public opinion. Ben Crump's office, for instance, is one that's participating in this, an attorney with his office. And he's, boy, I just think a hero of an attorney in the civil rights actions and the work that he's done. But I think, too, people need to recognize the appeal is not on a civil rights let me rephrase that. The appeal is on very specific legal grounds. And so right now they're analyzing whether or not they have those legal grounds. And so you and I talked about just a general is always ineffective assistance of counsel. They have to look and decide, do they believe that occurred or not? I'm not saying it did. He had great defense attorneys, but they're going to look at that. They're going to look at the Batson challenge. And one of the things I want to say about that is that's the challenge that a side can make if they believe the other side is striking jurors for the wrong reason during jury selection. The wrong reason is when it's any of the reasons you can't discriminate against people, whether it's gender, whether it's race. Now it applies to those entire groups of people. It started off as race. You can't strike someone because of their race. Well, they struck three African Americans from this jury, and they were comparable ages. I believe, Michael, they were all female and had some similarities to a white female who they did not strike. By they, I mean the prosecution, right? So the prosecution strikes these three African American jurors, prospective jurors, and the defense makes the appropriate challenge in the trial court during the course of the jury selection. And they make that challenge, and then it was on the prosecution to explain a right reason, a valid reason why
A
they struck.
race neutral reason.
Yes, thank you for that language. Race neutral. And they said it was because these three individuals were educators who were involved as educators with school age children. And they didn't want that. They differentiated from the one white juror that they didn't strike as an educator because her education was at a college level, the work that she did. So I guess what I'm thinking, Michael, with that background is there an appeal based on the record in the trial court of what the judge already decided?
Yeah, I think as far as the Batson challenge goes, a couple things are important. Number one, my understanding was that the white educator taught at a beautician school.
That's right. That is
So
true.
she was
At
teaching
higher
adults.
level
So the
ages.
point is well made.
Mhm.
Um, and the question that has been raised about the three female educators are, and we've seen this many times in voir dire, and you can speak to this. They were questioned during voir dire, and each one of them were questioned about teaching school-age children in the Callan County in school system. None of them had any connection at all to anyone in Carmelo's family, Carmelo, anything like that. They asked them, "Do you think you can be fair and impartial?" And they all said yes. We can look at the facts of the case, even though we deal with children, school-age children. We can look at this case, be fair and impartial. I wonder if that is going the reason they gave that they were educators of school age children is going to pass muster. Because think about the implications. Would then a police officer never be able to sit on a criminal trial? Would a criminal lawyer never be able? If you have any connection at all to some aspect of the case, then you could never sit on that jury. I find that hard to believe. So I wonder if that race neutral decision is going to pass muster. Now, I will say this, and you know this well, it's not a very high bar.
Right.
You don't have to prove it beyond a reasonable doubt. It just has to be a race neutral reason. And the court will look at it, give a lot of discretion to the decision ultimately made by the judge that it was race
Mhm.
neutral. He was satisfied. But I question that especially since the jurors were asked, could you be fair and impartial? They said yes. We've seen many times. Maybe they were exposed to some information about the case and they say, okay, can you be fair and impartial, even though you heard that particular thing? And they say yes, and they're allowed to go through.
Sure, I
So I
agree
think
with that,
those
but
things could be a question.
I think lots of people say they can be fair and impartial, but they still get struck because the defense or prosecution doesn't want to take the risk based on whatever it is that's a race neutral reason. And so in this case, for instance, I think it extrapolates too much to say, all right, in the future moving forward, if they could give that reason, then you could give the reason of not wanting any police officers. I think it hinges on the strategy of this prosecution. And if their strategy was to say, we don't want any educators of school age children, we don't want them. Because who knows what the prosecution thinks? Maybe the prosecution says, because those educators know what kids are like these days. They know that these kids might carry a knife, not because they want to kill somebody, but they all have these little pocket knives. I mean, who knows what educators might
Right.
know? So I think because the burden is high, it's hard to win on a Batson challenge. And because they gave a reason that is race neutral, I just don't know that there's grounds for a successful appeal. It doesn't mean that it may not be appealed. I
Mhm.
don't I don't know that the grounds exist on the face.
Yeah, fair enough. I mean, I agree with you 100%. My only other thing I would say is that when you see it happening three times over,
Yeah.
the suggestion is it's not individual, right? You're not looking at the individual, you're looking at something else. So that's what I would argue. If all three of them you didn't believe that they could be fair and impartial, all three of them you had a problem. None of them were able to sit in judgment in this case. So, but teachers are. They've always been a problem. I can remember a mentor of mine not liking teachers on his juries in general, regardless of who the defendant was, because teachers could be bossy. They were used to holding court. You didn't want them sort of, and you kind of look for certain personalities to mix and match in these juries. It goes that deep. So sometimes teachers were a problem. So there's could be lots of reasons, but again, that's not the reason they gave. They gave the fact
Right.
that they were educators of school age children. The only other thing I want to discuss as far as the appeal has to deal with that criminally negligent homicide charge, the judge denying it to this jury. The
Mistake.
reason he gave, I thought, was a fairly good one. I mean, I got to say, I agree on some level. So when you talk about criminally negligent homicide, Judge, what you're talking about is someone engaging in an act that they're not aware could cause substantial bodily harm or death. They engage in it and death or substantial harm happens. So it's a negligent act because you failed to perceive the
Mhm.
risk.
Mhm.
Manslaughter or murder, you know the risk. And what
Right.
the judge said was there's no evidence here that he wasn't aware. And he pointed to that conditional threat. where he said to the guy, "Touch me and find out." That says in the mind of this defendant, he was aware that whatever he had could cause some harm because it could protect him from whatever he was telling them not to do. So therefore, that criminally negligent homicide charge was not one to go to the jury. I kind of find that to be persuasive.
I think it's a persuasive argument, but I struggle with it because I also feel like if you look on the face of the language, recklessly causing the death, and you're right, that means there's this unconscious disregard of substantial and unjustifiable risk. Who's to say his state of mind better than a jury? And I feel like had that been another charge available to the jury after hearing the evidence, that it would have been an appropriate finding of fact for the jury to make to decide that evidence supports manslaughter, murder, neither. But that's because I would always caution on the side of let the jury have it and decide based
Mhm.
on the facts versus if you make that decision as a judge, I believe that's something that they're going to appeal. The judge gave a reason. I'm not saying it's not a valid reason to not say manslaughter is one of the charges. I feel like perhaps that should have been something for the jury to determine what the facts supported. I have to go backwards and just say one thing about the teachers. I was surprised there were three people who were educators, that there are three African Americans and a small number of African Americans pooled, and they were all educators. I thought, wasn't that
Mhm.
interesting? Because I was
Yeah.
surprised by that. So, Michael, one of the points I wanted to ask you about is he has been transferred, which is very typical after the conviction from the county facility to the Texas state prison system. But what I found interesting was that was done as an expedited transfer. Why would that be an expedited transfer in your experience?
Well, my understanding was that they felt that there might have been some danger to Carmelo Anthony. He's been in protective custody, is my understanding.
Yeah, yes.
So they wanted to expedite the transfer for that. But I will say this, that doesn't match up with my experience. I always found that people were in more danger in state prisons than they were in county jails.
That's what I was.
Um,
Yes.
yes. So, we saw this interestingly enough in the Richard Allen case, right? Where
Mhm.
they transferred him to a maximum security prison. And there was some suggestion that they did that to put pressure on him or whatever. So again, I'm
And
not
he
I'm not
felt
casting
it.
aspersions here, but it doesn't match up with my understanding of how the system works and the various levels of safety that you experience and why a transfer would happen on an expedited basis. Um, I haven't seen any reason giving for that expedited basis. Again, the only thing I've heard, again, didn't make sense to me was that there might have been a safety issue and there were some guards in the county jail who were giving him preferential treatment, and they didn't like that. That was something I heard as well. Cannot verify that. So that's in play, but I don't know why, and it doesn't line up with my understanding and experience.
And Richard Allen, when he went to the state system, his health deteriorated very, very, very
Yeah.
quickly. Physically, visibly, you could see it was going down quickly. And I thought too, maybe the safety issue is security. So if there'd been death threats, et cetera, we know county
Yes.
may not have the same number of resources to protect society and the person, and the state may have more resources. So I thought maybe that too. But I thought the same thing you thought, which is expedited. But the reason for the expedition, I would be concerned about what happens to him in state prison as well.
Let's move
Yeah.
on to our next story. Interesting story coming out of Wales. Tell us about it.
So this is a case I brought to the table for us to talk about because it was a fascinating issue. Bevan rather, Bevan, in Wales. He killed his 2-year-old. They call her stepdaughter. I don't know if he and his partner were actually married or not, but it was his partner's 2-year-old beautiful little girl. And he killed her. And he did it. It had to have been a mad rage that he did it in because she had more than 100 external injuries to her little tiny body, beaten black and blue. Literally, she was only 2 years old. This happened in July of 2020. Well, I applaud the justice system in Wales because not only did they charge him, they tried him, and he was convicted for the murder of the 2-year old. Her name is Lola James. All right. So He gets convicted for the murder of Lola, the right outcome, in my opinion, and he receives 28 years to life. So here he is serving his time.
I just
Fast
wanna
forward.
interject one thing if I can,
Yes.
Judge. The mom was convicted as well.
For 6, and did get a 6-year
She
sentence.
got a 6-year sentence for allowing this to happen because the claim was while
Mhm.
she had gone to sleep, he got up and committed this act and was yeah, and again, I think the coroner said it looked like she had been in a horrible car crash. That's how bad he had
Yeah.
abused this poor child.
There's no way mom shouldn't have heard the little
Thank you.
girl crying and
Thank
screaming,
you.
all the injuries that were happening, the breaking, the all of, I mean, it's a,
And it
you
had
know,
been ongoing.
yeah,
And the
children
claim was
are,
she was
yeah.
abused as well, but that's no excuse.
Yeah, it's no excuse. It's no excuse. And children are my passion. And to think of what this little girl endured. So, absolutely the right outcome in the criminal justice system. But the question I want to ask all of our viewers is it justice? What happened next? And here's what happened next. In 2025, he is serving his sentence, and there are three other convicted felons: Mark Fellows, Lee Newell, and David Taylor. Well, they get into his cell and they stab him more than 30 times. They even put him in the bunk to act like maybe he's asleep or nobody will notice. And he ended up bleeding out and dying. But listen, we know what happens to child killers when they get to court. I mean, to jail. You hear this. You hear that the one thing, the worst thing you can do to then end up in jail because people are going to get you for it is a crime against a child, much less the murder of a 2-year-old. So is it justice? Is it jailhouse justice that truly he got what he had coming, Michael?
A lot of people would say yes, but it's always struck me, Judge, and,
Mm.
and we all know this, right? You don't have to be involved in the system to know that there's this whole sort of moral code that exists in prison. These are guys who they were already murderers and doing God knows what,
But
but
not of
yet
children.
right, but the guy who comes in who does things like and I think there's other things that they have issues with. Elderly people sometimes, you'll find there'll be problems molesting or hurting children. They will take, some sort of revenge on you. But it's just interesting. I always found it interesting that, they choose these little moral codes that they have and will exact justice. And these guys decided to do it and knowing that at some point there was nowhere to go, so they were going to be found out and end up spending the rest of their lives behind bars. That's how important it was to them to exact this type kind of revenge. Is it justice? I don't know, Judge. I'm not all for the Hammurabi Code. The eye for an eye.
Yeah.
It's an awful thing that Kyle Bevan did, but there's got to be something that separates us, as human beings and the justice system exacted its revenge, exacted its, pound of flesh. He was away for a long, long time, wasn't going to be able to hurt anyone else as far as children are concerned. I think that's justice and what these guys are deciding to do, especially who's deciding to do it. Who are they to decide what justice is?
Well, that's what I was gonna say is we know that in jail, it is its own city. It is its own set of rules. It is its own government. And by darn it, every time I see something happen in jail, it's because of that, because of the code that you've mentioned. Now, interestingly, all three were convicted of his murder, of Kyle Bevan's murder, of course. We're not at all surprised by that. And two of them had been serving life sentences for murder, to your point, before they committed this crime. So they might have felt like, who cares? I'm here anyways. We're going to do to this guy what we think he deserves. Now, I agree with you. Is it justice? I don't believe so. But it does shine a light on the fact that there is a hierarchy inside our prison systems and what they believe to be justice.
Yeah.
And it happens probably more often than we talk about.
And it's not just this kind of thing, Judge. I grew up in a rough area,
Mhm.
and where I grew up, guys who went to prison were kind of like revered. It's odd. These
No.
guys would go into prison
Huh.
and they would come out. So these are guys who are living on the fringes. We always had this little joke between us, people living on the fringes of society. I
Mhm.
got that from one of the shows I watched. But anyway, I liked it, the
But
fringes.
it's true.
And so they would be unhealthy, they would be thin, they're running the streets, they're doing things, they would go to prison. and all they'd be doing is eating and working out for the first time, right? And
Okay.
they'd come out and they'd be buff and they'd look great, and everybody would be like,
Hardened.
wow, and they were kind of like, oh, you survived prison. That gave you some credibility. And they would tell stories about how, you know, based on the hierarchy, I want to put up a quick picture here because this was a
Mhm.
story that from a couple years ago. We recognized this guy, Luigi Mangione. There was a
Mhm.
lot of talk about his haircut and the fact that he always had nice haircuts when he went into court. And you know how they shave your head when you go into prison.
Right.
And they're saying that's signs of the hierarchy. Somebody in prison, wherever he was looking out for him, taking care of him. He was getting commissary. That's people send
Wow.
you money and send you things to keep you going in prison. And he had some sort of protection. So there's things like that, simple things like a haircut. There's things like I heard a story, a guy said, "Look, you know how you have a cell, 2 people in a cell, sometimes more in certain circumstances, and there's a toilet in the cell. If you're the top dog in the cell, remember, it's like an animal kingdom in there.
Right. Oh, yeah.
You tell those bunkmates, that's a no poops, toilet. So, only one who can poop on that toilet is me.
Is the
You
number
guys, you've
1.
gotta go someplace else you can do number 2 somewhere else. That was a way. They would make their guys sit down when they would do number 1. Things like that. This is the
Mhm.
mentality you're
It
dealing
is
with.
the mentality.
The
Yeah.
last one was a guy. His name was Moet, and I've been for years wanting to do a movie or a story about this guy. He was a guy who was like revered in the neighborhood. He was just a tough guy, ran a couple of gangs and stuff. And
Mm.
whenever he would go to prison, he would come out not buff, but fat. And the point was the food they give you in prison is not enough to make you fat.
And it's not good.
So if you're coming out fat, you know what that means?
Oh, you're taking it from other people.
You're
I just
dominating a lot of other people,
got
taking
it.
their food. It was a sign of his
Power.
dominance and power. Other people would bring him food, take care of him. He would take other people's food or have people take other people's food. So
Mm-mm.
it's just this odd place, this odd mentality that's going on in prison. Gosh, I I remember I knew I could never survive in prison. I've gone into
Mm.
prisons to do interviews with folks, Rikers
Right.
Island, all that stuff. It is a scary, scary place. And one last story. I remember going into Rikers Island with a production assistant. We were going in to do some interviews. Literally 10 minutes in, it's so overcrowded. We were so close to some of the inmates. We were going into a gym area. He couldn't deal with it. He said, I can't deal with it. He got claustrophobic. He got scared, had to leave. These are the energy and the danger that you feel. It's it there I can't even explain it really. I can't even explain it.
Well, I'll say I just want to add to that. When I was on the bench, I saw lots of people who had committed lots of crimes or accused of committing heinous crimes. And Michael, I can tell you, in 10 years, I saw one adult who I took one look at and I got chills because I thought that one adult would kill anyone in this room if able. And so you also see some of these people are just not good people. They're just not good people. And I have always said, I knock on wood, never would want to go to jail, to prison, to any of it. No way.
That's really the problem. And you know what? I can tell you from growing up in a tough area, there's usually only 3 or 4 people who are just really just bad, and they make
Mhm.
the whole area scary. They make the whole area seem bad because 'cause they're just bad. So you imagine being confined behind 4 walls with those guys.
No.
Quickly, let me just go through, we've seen this throughout some of our high profile trials.
Yeah.
Jeffrey Dahmer in 1994. He was bludgeoned to death with a gym weight
Mhm.
bar by an inmate at Columbia Correctional in Wisconsin due to a complete lack of remorse. And apparently, he was mocking other inmates by shaping his food to look like limbs. So he was pissing people off and got himself killed.
It's not
Whitey,
funny, but it's
is
like
that
if you want to
crazy?
survive, you don't do that shit.
He didn't want to survive. He's crazy. Whitey Bulger, I don't know if you remember him. He was a gangster back in the
Mhm.
Boston area. He was a mob boss, FBI informant. He was actually beaten to death with a padlock and a sock within hours of arriving at his prison in West Virginia. And most recently, you remember this, Derek Chauvin.
Oh, yeah.
He
Oh,
was
he
stabbed
was
22
lucky to
times in
survive.
Arizona federal prison in a law
Mhm,
library.
mhm.
He survived, and they had to, intervene in this, otherwise he would have been killed. But so, this thing is real. It goes on. Prison justice is no joke.
Yeah, no joke, and I want people to weigh in what you think of the fact that this James Bevan was killed by other inmates because of what he had done to a beautiful two-year-old girl. I'd love to hear what people think of that.
All right, let's move on now to our third story today. And this one's a little lighter, but it's important nonetheless.
I'm gonna kick off this story while you pull that
You
up.
do it. Go
Patag
ahead.
Patagonia is a retail brand that I remember in high school.
Yeah,
All I wanted for Christmas was a Patagonia coat, and they were a little bit expensive,
they're
but
the
they
best.
were the it product to own. So start there. It's a privately held company. It's
Yes.
worth, I think $1.5 billion, but I
Mhm.
love their gear.
Yep, love their gear. So did this guy. His name was Win Wiley. Win Wiley is an outdoorsman kind of guy, and he would go out. But his claim to fame, Judge, was as this person, his alter ego, Patty Gonya. Get it? Patty
And
Gonya.
And add to Patagonia that he hiked in heels.
Yes.
That's what he did.
His thing was really all focused on sort of preserving the environment. That was his focus. Um, but at some point, he did a 360 and decided that he was going to go into the retail clothing business, enter into marketing, things of that nature, with the name Patagonia. Now, Patagonia had known about Patagonia and was okay with him using that name because, again, it's a homophone of Patagonia. And
Mhm.
that's what he was going for. That's clear. And he doesn't
You're right.
deny that. But they were okay with him as long as it was about these causes, about saving the environment and all those things. It was in line with the mission of Patagonia. But once he was going to start being in competition with them, they got a little irked and they decided to hit him with a lawsuit. What was interesting about this lawsuit is they're claiming that by going out there and selling Patagonia apparel and marketing under that name, he was weakening their brand. But because of public interest and he had a lot of supporters with his mission of saving the environment, they didn't want to come down too hard on him. The lawsuit was for only $1. So they just want him to stop. They don't want him going out there selling clothes that are in well, not really a competition, but would weaken the brand of Patagonia.
And I think it's the slippery slope argument as well. If they were to allow Patagonia to do this, then the next person that comes along that's using a name that sounds like Patagonia, they would arguably lose if they fought because they'd be, well, look at the precedent they set. They allowed this person to use it. So the next person should be able to use it too. So I think it's also to protect their brand Patagonia, not from this, but from in general people using the same likeness, which isn't allowed, and getting in competition with them. But I have to mention the competition part. Again, $1.5 billion in sales for Patagonia, the retail brand.
Mhm.
Now,
That's
this
a year. That's a
Patagonia,
year.
that's a year.
That's
Yes, a
yearly
year.
sales. So they are a
Yes.
big
Now,
company.
this Patagonia went viral, I think in 2018, but
Mhm.
to give you an idea, did raise $3.7 million for environmental nonprofits. I guess my point to that, Michael, is I don't think it's fair to argue he's competition because while that's fantastic what he has done for environmental issues, that's not the same as $1.5 billion in sales a year.
Well, I agree 100%. And I think Patagonia knows that as well, which is why they really fashioned their lawsuit to be about weakening their label, not
Mhm.
in competition or taking business away. They were saying it weakens their brand. The idea that he could go around with the name Patagonia, it be associated with Patagonia, and it weakens their brand in that way. the central issue here is that my understanding is there was an agreement or a compromise. So Patagonia, as I said, was aware of Patagonia, and they had come to some sort of agreement. And at issue is really that agreement. They say there was an agreement that said you wouldn't go into that area as long as you did performance art. You climbed the mountains in high heels, and you raised money to save the environment. We're okay with you, but you're not going to move into this other area that could potentially weaken our brand or, in fact, become in competition with us. He says that's not the case. The agreement was only for one show that he was doing, not overall. So he's claiming that. So I think he's got a couple of things there that he could argue. But I think at the end of the day,
Mhm.
what Patagonia is most concerned about is because, again, they're an environmental company. I mean, they sell clothing, obviously, but they're about the outdoors, right? So
Right.
they want to be seen as folks who support people who want to save the outdoors. So by going against him, they could be angering the people who buy their clothes. So they're very worried, but they feel like they have to protect themselves.
I do understand why they think they have to protect themselves. But again, I think this one's going to settle. To me, this screams settlement because
Really?
of both of their interests in environmental and because of the disparity between the earning. I just feel like there's got to be a compromise they're going to be able to reach and not go to court. Neither of them want to go to court. Well, he may not have any lose. Patagonia may not have anything to lose. But I do agree. I don't think Patagonia, the retail brand, wants to take this to court.
Yeah, so I guess the last check, and I did a quick search about what was going on. There is a lot of public pressure on Patagonia, so
Mm.
they're struggling with that. But I went to the website for Patagonia, and I saw that no merchandise. So he was selling merchandise, and he was continuing, but he's stopped now.
On
So
his
he's,
own, right.
yeah, on his
Well,
own, right? He
he
stopped
decided
selling the
to invest
merchandise, probably on
smart.
advice of counsel, right? Saying, look,
Yeah.
let's show good faith, because I guess negotiations are still sort of going on between the two. And I don't know, do you feel like there's s- I don't know, a common ground that these two can reach
Of course,
where Patagonia can maybe make a living at this, sell some clothing, and Patagonia can be okay? Do you think there's a middle ground, and what would that
of
look like?
course. This is one I really do, and especially if you look at both have environmental interests, I think that there can be specificity as to what Patagonia can and cannot sell that could allow him to do his art and sell his products, but Patagonia, the retail brand, would be okay with it. I think it's gonna settle.
Yeah, I think there's definitely space there. I don't know if it'll involve clothing. I think that's a bridge too far. I feel like Win Wiley, he made a choice that he knew would help him by choosing Patagonia. That's a conscious choice, knowing that the popularity of the brand would help him. He got, a lot of success as a result. He's created a persona, but he did it off the backs of a company that's been built. Again, we can say it's a $1.5 billion company, but somebody built that from a couple of shirts,
You're right.
right? So,
All right, that's
and
right.
it's a privately owned company. They have a right to protect their
Protect,
brand.
and that's
And
what
I,
it
I
is.
believe that. So if there's going to be a compromise, I think you allow him to do his performance art. You maybe have him, he can do some marketing, things of that nature. But I think the merchandise sales might have to go.
Oh, that's gonna be interesting to see
Yeah.
because I still think you could limit what he can sell, but he can sell some things, but we're gonna have to watch it and see.
Yeah, we absolutely will. All right. That's going to do it for this episode of In Session with Judge Astor. But before we go, Judge, I don't know. I gotta ask. I
Yeah.
know your youngest is off to college.
Yeah.
I know that's a little source of sadness, but
Yeah.
at the end of the day, that's kind of what you've been doing. What has that been like? I mean, I know I did it for my oldest, and it was probably one of the happiest times of my life. Number one, because college is so great, and being on college
Yeah.
campuses always makes me happy.
Yeah.
But also you have the other side where, once that child leaves your house for college, you've probably spent about 90% of the time you're going to spend with them. So there's the sad part.
Yeah, and my viewers may see me on air all the time to fill the space once they leave the house. I like a busy house. I have 3 kids. She's the youngest of the 3, going to a big SEC school, a fun
There you
school,
go.
a lot of great opportunities. I couldn't be more excited for her landing in the right place. But as you said, Michael, I mean, it's bittersweet. It's my last, and so I'm doing everything I can to spend all the time together, and I'm very proud of all my children. I'm very happy for all their successes, but the house is gonna be very quiet, so I haven't yet
Yeah.
really, accepted that part.
Yeah, it's always a bit bittersweet, and I just wanna tell a quick story before we go. You know, the youngest one, I know I think I met all your children, but the
Briefly, but you've
youngest
seen her more
briefly,
'cause she was
yes.
with
One of
you
them a
when
little bit more the middle one I met quite a few times. The oldest
True.
I met, I think, once or twice. But I don't even know if I've met your daughter, but I feel like she's a part of the family because we talk so much about her through the last few years, her journey through high school and all of that. And I can remember being so upset because we were no longer working together and we were all worried about where she was going to end up going to school,
Yes.
you know, and it was like the big question and she was deciding and I was hearing about all the choices and then, it happened and then I wasn't aware of what the choice had been made. And when you finally let me know, I almost cried. I was like,
And I
I
was
wasn't there for the decision.
No, but you were one of the first people I texted. You were one of
Yeah,
the first people I had to text and say,
yeah,
"Guess what? She decided." And let's share a little bit of behind the scenes because the
yeah.
other thing is when we were on air together, you
Hmm.
and I both, and I think this is why we feel like such family with one another, because your youngest might be going to soccer and have to know, Dad, is it, this time or this time? Did they change it because of the weather? And so you'd get those texts and those
Yep.
phone calls on our breaks. And then I had my daughter, Katie, and I'd get those texts and those calls and all the things that you're navigating in high school with your kids. And so I think that's another reason because your
Yep.
youngest, I absolutely feel like I am completely invested in his life. And of
Right.
course, you're going to ask me where he should go to college
Wait,
because I know him.
hold on, Judge. Stop. This is mom. Stop. I don't have any more money for you. Stop. That was the regular for Judge Ashley on set because she would be sending them texts with voice, and they would call her on set all the time. And luckily, it was never on air; it would always be on a break, so maybe they knew it
Oh
was a
my
break.
God.
And the phone would ring, and she was like, "Oh, I gotta turn the thing on." And then she's like, "I don't have any money. Don't go over here. Go over there." It was so
That's
hilarious.
exactly what it
These
was.
kids
Don't
calling
be
from all
fooled.
over needing
Don't
stuff.
be fooled. Even when they move on out of your house, they still make
Yes.
those calls and texts for all of us. But,
Absolutely,
yeah,
absolutely.
it's
Well,
an
we all wish her
exciting
the best,
time,
absolutely, obviously. I'm sure
and
she's
you and
gonna do
I
fantastic.
Thank you. Yes, I'm very excited, very proud. And you and I are going to be talking soon to bring of course, if you all like, please subscribe. We're on
Mhm.
Substack and we would love to have you join our conversation. But we're going to start doing some behind the paywall special things for our subscribers that we're going to be bringing them as well and engaging with them in chats, Michael.
Yeah, we're still working on that. Like you and I are both new to this, so we're still figuring out the best way to get as much of us out to you guys, and so we're still trying to figure out exactly what this is going to look like. But we'll get that together real soon. Like I said, it'll be opportunities to interact with us, talk about these trials on a private basis where we can chat with each other and really share ideas, which is really, I'm looking forward to that, and that's what
Me too.
this is largely about. It's just keeping the conversation going.
And it's so important because it provides transparency and it protects all of our constitutional rights at the end of the day.
I agree 100%. All right, Judge
Right.
Ashley, go back and do the mama thing.
Thank you.
Truly appreciate it, everybody, for watching. Once again, this will be up on YouTube, Substack. Please like and subscribe anywhere you do watch this stuff. If you're able, consider getting a paid subscription to help support us in our ability to bring content to you, all the great content that we do. All right, folks, have a wonderful afternoon, and we'll see you again real soon here on In Session.